So we are now live again. Welcome back, folks. Sorry for the delay. We are now going to do a legal update. Well, an update on number one, first 10.1, election overview of the Métis Elections Act of 2007. And I believe Riva Reset is going to be presenting. Riva, are you online there? There she is.
Hi there, I am here. I'm just going to start my video.
Excellent. Yeah, we see you, we hear you, Riva. It's all yours for the election overview.
Perfect. I'm pleased to be presenting just a quick overview on elections under the Métis Act, the Métis Elections Act 2007. And then I know we have the second presentation on harassment in the workplace. I didn't know if Hillary had any remarks that she wanted to make before I jump right into this. I don't know if Hillary is online.
Oh, she's here with us, Riva, and she
Okay.
says for you to just go right ahead.
Okay, perfect.
Thank you.
All right, again, so this is just intended to be a very high-level review of the Saskatchewan Métis Elections Act and the the timelines, those key dates, and some of the key players under the legislation of the Métis Nation, Saskatchewan. So you can skip to the next slide. And I am presenting out of Treaty 4 territory and the traditional stomping grounds of the Métis. And I know that many of you are attending virtually out of your respective treaty areas and your respective traditional Métis stomping grounds. So again, I'm very pleased to be presenting to you this afternoon on this topic. The next slide. So just briefly, again, I wanted to quickly just touch on our governance structure under the Constitution, and then this is also, relevant to the Métis elections. You could go to the next slide. First of all, we have the Métis Legislative Assembly, the MNS Legislative Assembly, and that is made up of collectively all the presidents of your locals, the Provincial Métis Council, Métis Women of Saskatchewan, there's 4 representatives, and then the 4 representatives of your Provincial Métis Youth Council. And then, of course, we're talking about our Provincial Métis Council elections and those key dates. So we can go to the next slide. So under the Constitution, the Provincial Métis Council is made up of 4 currently under the current Constitution, and we have the regional representatives, the members of the executive, the representative of the Métis Women of Saskatchewan, and then the Provincial Métis Youth Council. And there's 1 rep for each of those, the latter 2, although I do believe that under the Constitution Act, that there's like a triggering provision under the Constitution as worded that speaks to parity. Once there's parity and, equal number of women on council, I believe that provision, I believe that nullifies the 1 rep. And that's just based on my recollection of the Constitution. Next slide, please. So under the provincial elections, the executive is made up of the president, the vice president, secretary, and treasurer. And those offices are elected provincially, so province-wide by all members, your citizens, your voting electors of MNS. Next slide, please. And so what establishes your framework for the MNS elections is, well, it's set out at Section 1 of the Saskatchewan Métis Elections Act. And right at the outset, the purpose of the Elections Act is to establish a dependable regime for the election of members to the Provincial Métis Council, and that promotes the meaningful exercise of democratic rights and freedoms of the Métis in Saskatchewan. And so that's set out, it's your first provision that's set out in the Métis Elections Act. So as far as again, I just mentioned earlier that your Article 8 of the Constitution of MNS, it provides that there's an election for the PMC executive and the regional representatives. Now, under the Constitution, it's to be held within 4 years of the previous PMC election. Again, the PMC executive is elected by the total membership of Métis Nation Saskatchewan. And then your regional representatives are elected within the respective regions. And again, that's set out, the process is set out under your Elections Act 2007. And next slide, please. So we've got some key deadlines that are set out. This slide, it speaks to our election period and your nominations period. So under Section 28 of the Election Act, the election day will be fixed by resolution of the Métis Nation Legislative Assembly. Now, the election period, that begins 35 days before the election day, and it ends when the polls will close on the election day. Now, the nomination period, it runs from 9 a.m. on the 35th day before the election day until 2 p.m. on the 30th day before the election day. So you have that more limited time frame. Next slide, please. Now, the MNLA establishes that the Chief Electoral Officer is appointed by resolution of the MNLA. And so under Section 92, the term of office is for 7 years. Section 92 also has some additional provisions that is during the good behavior of the Chief Electoral Officer. And it also provides that the Chief Electoral Officer can only be removed for cause by resolution of the MNLA. And so for cause, my interpretation would be similar to just cause in employment law. And so that would be a very high threshold for very serious misconduct. So it is a high threshold, and that would be the only instance that the CEO may be removed. Now, the CEO's duties are also set out at Section 93, kind of more specifically. And, you know, it also gives us a bit of an idea of the level of discretion that a chief electoral officer has in administering elections under the Act. You know, the whole intent is to allow the CEO to make decisions, like they are tasked with interpreting and administering elections under your Elections Act. Of course, their discretion is going to be constrained by the Act itself. So if the Act says a decision can only be made by this body, then obviously the chief electoral officer could not make that decision. But the act does contemplate that the chief electoral officer does have discretion to interpret the Elections Act and to make, I guess, judgment calls. They can delegate some of the roles under the act that's set out at Section 93 as well. And Section 94, actually, it does speak to this authority of the chief electoral officer to adapt the act. If situation arises where it's emergency, like almost like an act of God, or something that an urgent nature comes up, and the act doesn't really suit those purposes. If in the chief electoral officer judgment, if in their judgment, they have kind of decided that the act as it is it doesn't speak to that, right? It's an unforeseen situation. There are powers. Now, those powers have to be acted on or exercised reasonably. But there is there is an authority to adapt, a provision of the act or certain provisions of the act is so far as the urgency requires. But it has to be, the language of your Elections Act at Section 94 is pretty clear that these are very unique circumstances. And again, kind of along the lines of an act of God or emergency, urgency, completely unforeseen circumstances. Next slide, please. Now, as far as the holding of the elections under the Act, again, the election day is fixed by the MNLA by resolution. And then following the resolution of the MNLA, the chief electoral officer issues a document that's going to specify the election day. So that will be identifying the day that the election will be held. Again, the election period starts 35 days before the election day. And then the election period will end after polls close on election day. Now, after the declaration of the election, your regional returning officers, they each will provide a public notice that relates to the details of the election. So that includes, the full name and contact information for all candidates who are running for each office, the name of the region that the given region that the election is going to be held for, and the location and the hours of each voting opportunity in the region. Next slide. For holding an election, so under Section 32, the CEO, or sorry, the regional returning officers are to establish polling stations. So that's set out at Section 32 of your Elections Act. And the CEO, the chief electoral officer, gives public notice of the name and address of the regional returning officer, and that's set out at Section 35. But generally, the chief electoral officer's duty is to establish the office in a place that's easily accessible. We're promoting accessibility to the democratic process, and to keep that office open to the public, the voting public during the election period. the regional returning officers are responsible for establishing at least one polling station for each of those regions, and they need to do so in accordance with the direction of the chief electoral officer, again, who has that overall discretion and responsibility for elections under the Act. And I believe I had covered those last 2 points. Could you go to the next slide? Now, there's 4 ways that voters or your electors can vote. The first one is in person at the office of the regional returning officer. The next one is in person at the polling station on election day. Third, in person at a polling station at an advance vote. And fourth, in person at a mobile poll. Now, the ways of voting, those provisions are set out, and the information kind of I guess the parameters for that are set out at section 41 to 44 of the Election Act. The mobile poll, just briefly, is there. It's intended to provide a way for electors to access the democratic process, to participate in vote, and electors who are unable to attend, who can't actually attend either the polling station or a regional returning officer, at a polling station. So, an example would be if there are citizens who are incarcerated. I believe there's specific provisions in the Elections Act that contemplate that. But the language is set out at section 48 of the Elections Act. And, it's if a voter is shut in or unable to vote at either the regional returning officer, at the office of the regional returning officer, or at the polling stations, they can make a request. So this is done on request, but the request must be made before 5 p.m. on the 12th day before election day. So these mobile polls, they are established on request. And so again, like the whole intent here is to promote access to this process. Your provisions as far as, the advanced vote requirement, those are set out more specifically at section 44 of the Act. We can move to the next slide. So this, just briefly on the nomination of candidates. Obviously a person must be an eligible voter under the Elections Act in order to be eligible for nomination. If running for regional representative, your candidate must live in the region where they are seeking nomination. The prospective candidate will need to file the the nomination papers, and as required under section 23 of the Elections Act. Those nomination papers do need to be signed by at least 5 other eligible nominators who are also eligible to vote in the Election Act. And then lastly, your nomination papers, your timeline for getting those filed is during the nomination period. And again, that's between 9 a.m. until 2 p.m. On the 9 a.m. on the 35th day before the election day until 2 p.m. on the 30th day before the election day. And those are some of the key dates. I'm not certain if I possibly, no, I think that was it. I know that you're on a bit of a time frame here, a time crunch. Briefly, the Elections Act does provide for, I guess, um, remedies and other ways that there can be challenges to the election results, including like a judicial recount, and there's provisions set out in the Election Act under, I believe, Section 79 of the Election Act that kind of sets out what your parameters are for a judicial recount. And that's a process that is started by application, court application. And it needs to be brought within a certain time frame. There's pretty strict time frames for that. And then the other is an application. Again, it would be a court application for the voiding of an election. And the Election Act does set out kind of the grounds for either of those. The grounds for the recount would be set out at Section 80 of the Election Act, and the grounds for voiding an election are set out more fully at Section 82 of the Election Act as well. And again, for both of those, there's pretty strict time frames. An application for to void an election, it will need, let's say that there's a judicial recount that's in front of the court that's being decided at that minute, or sorry, at that moment. You have to wait until that decision is rendered. So until that that process is kind of gotten to resolution. And then you can bring your application, and it needs to be brought within 30 days of that. So
So Reva, thank you.
Mhm.
We're gonna move to questions now, and then we have two right now. Minister Bouvier, you're first. You got a question for Reva.
Yeah, just my question regarding nominations must live in a community. And I'm just wondering, if a person leaves to live in another community for so many years, how many months does he have to reside in a community when he comes back? In other words, to run for a position?
Off the top of my head, I am not positive here. Again, how many months?
Yeah.
Okay, I'm just gonna make note of that briefly.
Do you want to answer him? Yeah.
I think Hillary can,
No.
oh,
Okay,
No. Yeah, I can.
I think Hillary can speak to that here real quick. Go ahead, Hillary.
So under the Elections Act, determining residency, residence under 4 residence rules, temporary absence. Now this is with respect to a voter. A voter does not lose residence in the place of a voter's home or dwelling by leaving it for a temporary purpose, including the pursuit of education or employment.
So no timeline on that then?
Is there anything for candidates?
I don't believe.
That might be a question we'd have to ask our chief electoral officer.
there are
I thought
residents.
I thought it was 6 months.
It depends if they left for work or not, but yeah, I think that sounds familiar and reasonable.
But I've made note of that. We can follow up with that specific provision.
Just to add to that, John, regarding the 6 months and Minister McLennan, when it talks about locals, it says in order to be part of a local, you have to reside in the place for 6 months. And there's nothing in our constitution that says people can leave, like for locals, there's nothing that says people can leave for work and come back. It speaks only to health and education.
Exactly.
Okay.
A resident.
But it is a chief electoral officer.
Yeah, but that is, chief electoral officer question. So we'll have to get back to you on that one, Minister Bouvier, for the exact answer, but we'll reach out to the chief electoral officer.
Okay, thank you.
Thank you. Secretary McCallum.
There is reference in 412 for that. But anyways, Riva, thank you for your presentation. I just want to point out to the listeners out there, as well as our Provincial Métis Council, as Riva did do our references in our Elections Act. So our writ does drop April 19th, and it's there for the period from April 19th to the 24th. So that brings some stuff that needs to be addressed internally with the MNS in regards to that President's Hockey Tournament. And May 9th to the 16th would be our regional office voting. May 17th would be our advance. And May 24th is our election day. And so I wanted to bring that to our attention one more time. But the other thing that I wanted to point out in regards to your presentation, I'm not too sure why it was even pointed out in regards to the Métis woman about parity, but we need to think about parity versus equitable. And as we know, the women are not on the ballot this election as it was being proposed at one point in time, or the youth, again, as President Autumn addressed, that there were other things that that they wanted to bring forth as the Youth Council. And so they are not part of the Elections Act as of today. And we, as it going into our MNLA this weekend on Saturday, and the three items, we have proposed 3 items on the agenda, and one is specifically to set our election date. So those dates are really important, and I think that each and every one of us need to keep those dates in mind, and I think that they should be recorded somewhere, and they'll probably be announced after this, after our MNLA by our Chief Electoral Officer. So thank you.
Thanks, Secretary. Yes, Mr. Kinsella.
I just want to, I'm going to be reaching out to the Chief Electoral Officer because that is their role in terms of, clarifying some of these things, because there's, a lot of discussion. I know in the past, the writ period is 30 days and the election period starts, the process of nominations and all of that is 35. And so in terms of the actual writ period, I will have staff reach out to the Chief Electoral Officer to ask that question for clarity.
Just to bring also in whether the Chief Electoral Officer and our legal counsel presented on the nomination period under 21.3, a nomination must be made by filing nomination papers to the at the office of the Chief Electoral Officer anytime between 9 a.m. on the 35th, 35 days before election day, which is the 24th. So your 35 days is April 19th at 2 p.m. and on the 30th day before election day. So it is April 19th, but that
I understand the point you're making, and I will check with the Chief Electoral Officer because there's still confusion about it. I understand you're set on that. I will speak to the Chief Electoral Officer as that is their role to give clarity, and I will get the direction from the Chief Electoral Officer. Thank you.
Thank you.
Excellent. Thank you. All right, seeing no more questions, I'd ask Riva to now do the presentation on workplace harassment update. And again, we'll take questions after the presentation.
Chair, just so I'm clear as far as my timelines, if I need to hop over slides or kind of slow my pace, how much time should I budget for this remaining part?
Do the presentation. You're on the agenda. Do the presentation. Don't dawdle like you're, walk into a terrible appointment, but yeah, explain the way it's got to be explained. We don't want to short shift this because this is important for all the staff inside of the MNS, for all our citizens to understand our harassment policy. So this is important, and give it the time that it is due.
Can I ask a question on the previous presentation?
Real quick, Minister Bouvier, yes?
Good, my question is regarding people, staff that are working and plus elected officials. And when they're going to run for politics, and I'm just wondering about the campaign situation. When does a staff can campaign, and when can a electoral person campaign, and what are the consequences if they are campaigning behind the MNS?
Okay, Richard's going to speak to that, Minister.
So we currently are having, because we have not had that clarity, so they're being finalized, but we are drafting policy on that currently, and we have on January 28th, we have an all-staff meeting where we're going to talk to staff about policies in terms of if a citizen working for our government decides to run, and then also in terms of what does that mean for citizens who work for us or any staff person in that matter that want to support any candidate that is running. So I'll start with the latter, and we've made the decision at senior management that we are not larger governments, we're smaller, and so we are making the decision that no staff can participate in campaigns. However, if a staff person decides to run, their job will be protected because they have the right to run as a citizen, and so their position will be protected. We'll be speaking to the Chief Electoral Officer for clarity on when individuals can start campaigning. My understanding is they've been giving advice already, but I'm going to ask myself, as I have not had a discussion with them about it, and I'll be asking the question about when they can. Let's first say, for example, the answer is, they can start well before the RIP period. An individual can start campaigning well before the RIP period. Well, then the answer would be, then you'll have to take leave without pay for that period if you're going to start campaigning. But all individuals who decide to run, who are currently employees, will have to take leave without pay during the RIP period. That's where we're currently at, and we're developing the rest of that detail. And then once we have it, and we're going to be presenting it to our staff, we'll share that with you all as well so that it is clear.
Thank you.
Excellent. All right, thank you. Ms. Gervais.
Yeah, I had my hand up before. I must have let it down or whatever. Just a couple of questions, and we dealt with this last election as well. So, Richard, we need clarification as well, as when you said staff and would have to take leave without pay. We had this discussion regarding access to M&S equipment, vehicles, things like that. Can we get you to bring that back for clarification?
Yeah, when they take leave without pay, they're not using any work equipment or, the only thing they would have access to is the same that anybody running would have access to is all of the information on our websites, like generic information. But no, they cannot use any of our resources to be able to run in an election.
Yeah, just like we did last time.
Correct.
Thank you.
Thank you. Okay, so now Reva, back to you with the preventing workplace harassment and violence. She muted there. You're muted still, Reva. Oh, they're unmuted now. How
I'm
about it?
unmuted? Okay,
You're good.
perfect.
Yeah.
Okay, so there should be a PowerPoint
Yeah, it's coming up right now.
accessible. Scissors. Okay.
There we are.
Okay. Sorry, my son just poked his, I don't know, buddy, just, that's okay. Okay, so the top, I've been asked to, I guess, provide an update as far as there's actually been some changes in the legislation and the rules that apply to employers, and to give just a bit of an update on the state of the law on these two important issues, and which I'm very pleased to be speaking to, and I'm pleased as part of the agenda for today's meeting. This is on our workplace harassment and workplace violence, and what an employer's obligations are in preventing that and providing a safe work environment. So we can skip to the next slide, please. And again, I guess I made my acknowledgement previously, but we can go to the next slide. So on this topic, I did want to just speak briefly to where the members of the Provincial Métis Council fit in this overarching obligation that an employer has to provide and support a safe work environment. Next, we will speak a bit more specifically on what those obligations are. After that, we'll speak to the workplace violence and employer obligations. Now, we included that because in 2022, there were amendments to the Employment Act that require an employer to have a workplace violence prevention strategy in place, and there were some other amendments to an employer's obligations. Fourth, we'd be just providing a brief kind of overview on the duty to investigate complaints of workplace harassment and violence complaints. And then last, any questions that you may have. Now, again, the topic is the employer-employee relationship here. So we are speaking mainly to the obligations owed to staff members and employees of the Métis Nation, Saskatchewan. So we can go ahead to the next slide. And to the next slide. So here, I guess, first of all, we want to just kind of set out, I just wanted to make a couple general remarks about, what are these obligations? And I'd say again, one of those obligations is doing exactly this, is keeping up to date on any requirements, any changes on the law and employment standards requirements. So presentations like this to the Provincial Métis Council or to any board of directors of an employer corporation that we have, these types of presentations and just are, I guess they are, they make employment lawyers very happy because it's just kind of one of those measures that we can be sure that we've taken and that an employer can show, well, we had this overview of our obligations on January 21st, 2025. And that just kind of goes to support a record that shows that the employer is meeting those obligations. And as part of the ongoing duty to provide a safe work environment. And again, I just kind of touched that there were, in 2022, there were changes to the Saskatchewan Employment Act. And then I also had a couple cases that I wanted to flag for you. We're seeing an increase in some of the penalties that are being issued in some recent common law decisions and some human rights decisions as well. There's also, we also find that there's some decisions by arbitrators that are helpful. So an arbitrator is someone who is, this applies to a unionized work environment, but the decisions of arbitrators are helpful because it will usually come in the context of a grievance. So let's say there's a harassment complaint, or there was an employer who made a decision on a penalty or a corrective measure because of harassment or maybe workplace violence issue. Then there will be a grievance. So the employee who's maybe had the penalty issued, they'll file a grievance, and then so an arbitrator decides basically whether the penalty or the corrective measure was a reasonable one. And so these decisions are helpful insofar as it helps us to know whether it gives us a sense of kind of what the scope of what a reasonable response might be. And so there are helpful precedents out there just to kind of, just give us an idea of what an appropriate corrective measure or whether an appropriate penalty might be. So I just wanted to, I think I had a couple cases in this presentation that I wanted to flag for you. The next, oh, sorry. Actually, sorry, can we go back? So those were kind of just some introductory remarks I wanted to make, just to kind of, this is why it's important. This is why it matters. Now, as far as your roles as members of the PMC, these are kind of the situations where an obligation may get triggered. As you are well aware, that the members of the PMC, you interact with other members, with MNS employees. Now, it may be employees of central administration, or maybe employees of within your own political or regional offices, contractors, volunteers, and members of the public. So in those interactions, depending on the circumstance, your obligations could possibly get triggered, or it's just something that you want to kind of be aware of as you're performing your duties, and wearing your many hats that you wear on the PMC. So we have each of these roles. They may require that you take a step or a measure to prevent and address harassment and violence issues. And again, I do want to emphasize that like a presentation like this is part of that, ongoing obligation that's owed to employees. So the next slide. As employers, so let's say as employers, when you're wearing your kind of employer hat or as part of the collective, the PMC collectively would be subject to the Saskatchewan Employment Act. And so this includes an obligation to prevent and address harassment and violence in the workplace. Now, when you are acting as supervisors, you're also subject to a personal duty to ensure that workers under your supervision are not exposed to violence. And so I just wanted to point out a couple examples of employer supervisor capacities. So again, I pointed out that many of you have staff that work within your regional office, within your regional offices, and in those interactions, if you're instructing, if you have staff that are reporting directly to you, you're definitely kind of bearing that employer, those obligations. Those are certainly triggered. Collectively, as a collective, you have one employee who reports to the PMC. That would be the chief executive officer. And also, to some extent, even in your dealings with the administration staff, or your portfolio directors that fall within a minister's mandate. So the Minister for Health, to some extent, is kind of acting in that supervisory capacity, which would trigger those obligations. So you want to be mindful in your interactions with your portfolio directors and the staff generally. Those are some examples that came to mind. The next slide. So, some examples where harassment and workplace violence can occur, between a PMC member and an employee. It often arises between employees, or between an employee and a non-employee who might be present in the workplace. So that might be suppliers, contractors, volunteers, or even members of your general public who have access to, or who are accessing MNS's services and programs. This being a government, there are a lot of situations that can arise where an employee might be exposed to a high-risk situation. whether it's high risk of harassment taking place, or workplace violence. The next slide. So when we are talking about harassment, this is a defined term under legislation. It's defined at section, we can go to the next slide. The definition for harassment's actually set out in the occupational health and safety provisions of the Saskatchewan Employment Act. This is because harassment is considered an occupational health and safety hazard. So I believe the workplace standards, employment standards, are set out at Section 2 of the Saskatchewan Employment Act. The OH&S rules, those are set out at Section 3 of the Saskatchewan Employment Act. And the Saskatchewan Employment Act is like, it's a substantial document. And so it contains all the rules, and then there's regulations that attach to each of those provisions in the Saskatchewan Employment Act. So if you are wondering where the definition is found, that's at Section 3-1 of the Saskatchewan Employment Act. Now, not everything is going to constitute harassment within the meaning of the Saskatchewan Employment Act. Again, this presentation is about harassment within the employment, within the meaning of employment standards and employment legislation. So I just want to make sure that that's clear. I'm speaking to the harassment that's going to follow under this definition. So there's kind of two facets. So the harassment will be unwelcome, unwanted, or objectionable conduct, comments, displayed, actions, or gestures made on the basis of, we say, a protected characteristic or a prohibited ground. So if any of those, conduct, comments, displays, actions, or gestures are made on the basis of race, creed, religion, color, sexual orientation, all of those listed, those kind of categories, that's called harassment based on prohibited grounds. And that's those prohibited grounds are set out in the Saskatchewan Human Rights Code. So any type of conduct that's made on those bases, on those protected characteristics under human rights legislation, that would constitute harassment. Now, the second type of harassment is, I guess it's usually called workplace bullying. And so that would be any, again, unwelcome, unwanted, or objectionable conduct, comments, displays, actions, or gestures that would adversely affect a worker's psychological or physical well-being, which could cause a worker to be humiliated or intimidated, and constitutes a threat to the health or safety of a worker. So that's right there. This workplace bullying is considered an occupational health and safety hazard. So, but it does require those two aspects. So it has to have this adverse or this harmful effect on someone's psychological or physical well-being, and it must constitute a threat to the health or safety of the worker. So we can go to the next slide. Now, there's, I guess, a subjective component, meaning kind of what the person was feeling. So what the worker was feeling or the complainant was feeling. And then there's an objective component, and that would be kind of what an outside observer would be judging. So your subjective component would be whether the complainant felt harassed. And then your objective component, the test, is whether a reasonable person in the complainant's shoes would have felt harassed. And then this is bolded here. the intention of the harasser, it doesn't matter. Like if the harasser didn't mean to harass, it doesn't matter. Again, the question and the concern is more about the impact on the worker or on the worker. And that's whether they felt harassed and whether a reasonable person would have also felt harassed. So we can go to the next slide. Now, harassment, it can be either one serious incident or it can be a series of acts. Again, that single incident, it has to be very serious. If we're talking about a series of acts, it may be that each individual act doesn't seem serious if you judge it on its own, but if you view it as, as a whole, it may fall under that harassment within the definition of the OH&S provisions. So we can go to the next slide. There's no single form of harassment. We've seen, this including a broad range of behaviors.
Watching the road. Can you text for me, please?
Oh, I think, there we go. So there is, there's no single form. We often find that it's overlapping types of harassment. Sometimes it can be based on a prohibited ground, but it'll have also these undertones of social media or bullying. And so it can, again, the question is 2 slides ago, whether it met those requirements. Next slide. So we do have case law that kind of gives us a sense of what bullying in. Again, it has to hit that threshold, the single serious incident or the series of incidents. But that can include any of these examples here, depending on the situation at hand, whether it's persistently someone's getting picked on, belittling, demeaning, threatening job security, or overloading an individual with work that's, to be done in unrealistic time frames, making threats, treating people with a condescending attitude, issuing hostile emails or inaccurate memos about an employee. These, depending on the circumstances, could constitute the workplace bullying or that workplace harassment. Again, so like the second last bullet, treating people with the condescending attitude, maybe the one incident might not be so much. But again, the question is this creating like a sense of an unsafe work environment for this employee? Next slide. We also have sexual harassment, and this can occur where there's sex and sexuality is leveraged for power and control or to intimidate and embarrass a worker. So this can include inappropriate jokes, physical contact, stories and sexualization of the workplace can constitute sexual harassment. And sexual relationships between coworkers or coworkers and managements can result in harassment where there is a power imbalance. Again, this is all going to depend on the circumstances of a situation. The specific, whatever the specific case was in front of a judge at the time. But these are some situations where it has been found in the cases. Next slide. So we have an example here of sexual harassment that, joking's not an excuse for sexual harassment. So there's no kind of boys will be boys, like it's just a hard no as far as what an employer's obligations are to make sure that this is a safe work environment. And this is an example, this Sheldon and St. Mary's Ford Sales. This is an example of where the court did find that workplace jokes had a serious harmful impact on employees. In this case, the employee had complained to a salesperson, a colleague, that she wasn't being treated fairly when she was put in a new position following her maternity leave. On 3 occasions, a colleague made jokes that she should have slept with that the employee should have slept with their boss. And the employee did indicate that the jokes were unwelcome. So again, if you kind of think back to the definition of harassment, it needs to be something that's unwelcome. Or, conduct that the employee doesn't want. That's unwelcome conduct. In this case, the employee felt, and the court found that the employee felt disgusted, demoralized, suffered stress and depression. And it was found that these comments weren't just innocuous, kind of harmless jokes. And here we have both the employer and the salesperson both being liable for discrimination in this case. So we can go to the next slide. So harassment can, in some cases, occur over, and we're actually seeing this happen more frequently. We're advising employers more frequently about this type of social media conduct, where the harassing conduct happens over social media. We have people kind of freely, they're posting their thoughts and their feelings. More and more, we're finding that friends with coworkers, we have common friends, there's more overlap. And, this arises because in some cases, people can lose control of the content that they post. So, it might be copied by others or forwarded. It can, in some cases, be really hard to delete and easy to share. So let's say I made a post about something and I got second. I've seen this happen, if I get second thoughts about whatever I've posted, I delete it. But in the meantime, somebody maybe have taken a screenshot of the post. And so that screenshot gets forwarded, so that we're seeing that happen more and more, that we're advising employers on. And usually the social media harassment, like it's right there in front of you. You have it documented, right? Because these posts you lose control of them. They're easy to lose control of, and you have your direct evidence right there. Now, it can still be workplace harassment if it's done outside of work hours. And so there's a lot of case law on that. When is something going to be considered workplace harassment? It's when the conduct starts to impact the workplace, or when it starts to impact, the employer's reputation. It's kind of that off-duty conduct. So the threshold is when it actually starts to come into the workplace. Again, we're seeing more situations where, somebody might be out in public at a restaurant. You see them behaving inappropriately or making racist comments to someone who's serving them. It gets captured. And then they're, seen situations where there is, concerted effort for the person to lose their job. So these situations can happen, and that's the challenge is, when does this start to actually impact the workplace? And again, it's very context specific. The next slide. So we have a situation, again, I'd mentioned on arbitrator decisions. So here's an example of there was a grievance filed challenging this decision, this discipline. So in this case, the griever had been terminated after making Facebook posts that were offensive about a female victim. And the griever was frustrated at the time with the victim's failure to follow proper procedure during the shift. After the shift, the griever makes a Facebook post that was implicitly, so it may not have named the person, but if it's implied or if it can be through innuendo, if we can, if you can tell who is being spoken about, that will be taken into account. And so what happened in this case was that other workers had commented on the post and insulted the victim's work ethic and appearance. Well, what happened is these things often do snowball on social media, is it escalated to threats of physical and sexually violent acts. And, several hours after making the post, the griever deleted it and later tried to apologize. The next slide. And so as far as, sorry, my apologies here. I thought we had the outcome. So in this case, the griever had been terminated. Can you go back, please? Thanks. In this case, the griever kind of had lost track of, the griever tried to delete it and retract it, but there were two aggravating factors that made it more serious. The first was that, the arbitrator found that this was especially vulgar, the comments that the victim was exposed to on social media. And the other thing was that the arbitrator just disagreed that they could not justify kind of this conduct because of this victim's failure to follow the procedures at work. Like nothing justified this type of harmful act. So they couldn't rationalize it at all. The arbitrator found that the social media and the use of the social media was clearly, like, it was done maliciously, and that's not how you deal with these workplace concerns with a coworker or colleague. They found that, this was a completely unacceptable response, and, it ended up getting so out of hand that it did cause this victim serious harm. And so, and along those lines, it was found that because those posts were so vicious, and what it just kind of opened this really vicious can of worms, it was just completely out of proportion to the actual issue that was the source of the, this griever, the harassers. It was just completely disproportionate to what the harassers, frustration was. So we have, in that case, the termination was upheld. So we can just go on to the next here. As far as obligations, so the employer generally is, we have this obligation to ensure that to the extent that it's reasonably practicable. So I do emphasize that you don't have to do every single thing under the sun to make sure that workers are not exposed to harassment in the workplace. It has to be practical. And it has to be reasonably. So it's not like a standard of perfection. It's not a standard of, like I said, everything under the sun. It has to be reasonable. Now, supervisors have a duty to ensure that all workers that are under their direct supervision and direction are not exposed to harassment. And workers have duties as well to refrain from causing or participating in harassment as well. So although, like, the Saskatchewan Employment Act is concerned about protections for employees, they certainly are, it doesn't mean that workers are immune from the obligation as well. They have this duty to refrain from causing or participating in harassment. The next slide. So, as far as what the obligations for harassment, workplace harassment are, Section 36 of the Occupational Health and Safety Regulations, it requires that employers have a harassment policy in place. So that's mandated that an employer has to have a harassment policy in place. And so this is mandated. So by all means, in some cases, we have employers that come to us that don't even really have anything in place. The other thing is the regulations set out exactly what the specific elements of your harassment policy need to have. And so that's your number one easiest way to comply with your OH&S obligations, harassment policy in place. Next slide. And again, just like any harassment policy or any other workplace policy, it's only as good as insofar as you use it and you refer to it. So you never want to see a policy kind of gathering dust. You want to make sure that you've taught your employees about it, that board of directors or members of Provincial Métis Council are aware of their their obligations to, support a safe work environment. And all those items. Kate, next slide. So there are consequences for, harassment. And in some instances, depending on how serious the conduct is, it can be grounds for termination for just cause. Again, zero tolerance doesn't necessarily, it's not going to mean it's going to be automatic termination. It will depend. But when an employee engages in this type of behavior, there can be significant legal proceedings that get triggered. And so we have those set out here. It could be, an internal investigation, or you could have the Human Rights Commission or an OH&S officer investigating into the matter, or any of those other items. Next slide. Remedies. As far as remedies for harassment, there's different remedies that are going to be available in different forums. So if you bring a harassment complaint on the basis, let's say under the Saskatchewan Human Rights Code, there are certain remedies under that. So the remedies are going to depend on the situation and the wording of the policy. And, in some cases, it can be back pay. Let's say it was brought under the Saskatchewan Human Rights Code. If it was dealt with kind of more internally and there was no challenge after that, there can be, discipline. The employee can be discharged. The harasser could be, directed to apologize. And in some cases, there can be apologies that can be mandated by your decision maker, like by a tribunal. Next slide. So under the Saskatchewan Human Rights Code, here's some examples of remedies that might be available if you go to the commission. So reinstatement, lost wages, and damages for the kind of mental anguish or I hate that term, hurt feelings, because it's kind of a loaded term now, but there can be damages for those negative impacts harassment has. Next slide. There's remedies under the Occupational Health and Safety Act. Again, I'd mentioned that an occupational health and safety officer might get appointed to investigate into this. And in this case, if what happens is it can be an offense under your OH&S rules of the Saskatchewan Employment Act. And usually what happened would there be a notice of contravention, and if the employer doesn't remedy the situation or do what the OH&S officer says they need to do to address the situation, then it can be an offense under the act. Next slide.
Hey, Reva, we are going to be getting a little tight on time. So if you could just go a little bit higher level on this particular unit, that'd be good. Thank you.
Okay. All right. I guess kind of overall, I did actually, I think this was kind of the last major topic that I wanted to cover. But there were amendments to the Employment Act about having a workplace violence policies and procedures in place for all workplaces. Before, it only used to be up for employees or employers that had up to a certain number of employees under their, within their operations, but now it's now required. Next slide. And the consequences for this can be serious if you don't have, a workplace prevention policy or plan in place. And this is kind of a tragic story. This is a tragic story that kind of triggered this legislated requirement that all employers need to have a workplace violence prevention policy and plan in place. And in this case, it was a nurse who had been harassed, frequently harassed, and tragically, she had been, the doctor who was harassing her eventually killed her. And so what happened from this is this caused an outcry for workers, and Saskatchewan, actually, I think Ontario was the first person who required or mandated that workplace violence prevention policies be established. And then Saskatchewan followed suit, I believe, a couple years later. Next slide. So, there are consequences and costs of workplace violence, and that can be felt both internally, externally, and obviously, the safety and risks to your workers that you have, that you certainly want to ensure are protected from these incidents. Next slide. And so, okay, we can go to the next year. I just wanted to touch on just briefly, the violence, workplace violence, again, it's going to be a defined term. We have it set out at section 326 of the OH&S regulations. And again, just kind of, I guess, taking it more high level, as far as members of the PMC, and depending on what hats you're wearing, your obligations might be triggered at any point. And what the obligations are is going to depend on what your interaction is. If it's in your capacity as supervising somebody within your regional office, or if you have an employee who's working in your regional office who, if there's a risk of a real safety risk, and also, if within your regional offices, you want to make sure that you have a workplace violence prevention policy in place. You need to have this in place. So I want to just emphasize that you want to make sure that you have that just in any event, especially if you have staff that are working really frontline with publics and members of the public. Next slide. And I think, what we have is that now, again, what is required in your policies, it's set out in the legislation. And maybe what I can do is I can send this PowerPoint to Hillary, and because this is helpful, especially because I know many of you have staff that report to you within your own regional offices. You're going to want to make sure that you have these types of policies and protections in place, and especially this one. So this is a relatively new requirement on having these workplace violence policies, and we're finding that a lot of employers are trying to get themselves caught up here. And so what I can do is I can send out this PowerPoint, the slide deck. Skip to the next slide.
So Riva,
That hits on all those elements that you'll want to include in your workplace policy. And always helpful to be a resource person if you're wanting to establish one in your regional office.
Excellent. That's a good point. And so I noticed after this slide, it's all about case studies. So I think we're good there. Just there is policy here at the MNS regarding harassment and violence in the workplace. And we do have this deck and the participants do have it already.
Okay.
So you don't have to worry about sending it into Hillary, but we do have a couple of questions. And I'm gonna throw it to Mr. Tex Bouvier for a question that I believe Mr. Quintel has something to add.
So my question is pretty difficult because a lot of our Métis people are colonized and our First Nations. They need hands-on workshops because they've been violated by colonization and generational effect of residential school and coming back from the army. So the modern world has their colonial rules. The cultural world, they need hands-on workshops, knowing that they've been violated and that it's things that because they carry that hurt. Not one person should say that they don't carry that hurt, because we all do, because we follow the modern world today. But a lot of us are coming from a Métis and First Nation perspective. And you have to look at it that way because we're discriminated. And now we understand their modern rules, but do they understand our cultural rules? You know, that's another thing that I like to bring up, because the harassment that we're treated unfairly when we went to school. You know, I went to school, I was slashed, I was trapped every day because I spoke my language. And then I came out a really harsh person just because I was trapped. I was a target all the time, every time I wanted to do a cultural thing or speak my language. And then all of a sudden, when I work in a different place, sometimes it comes out because they're trying to change my way to be colonized as how Canada wants it. We have their rules, but here we are, Métis Nation. What are we following? Are we following the colonized rules, or are we going to follow the cultural rules, hands-on? You know, so we need to be treated with the same respect, so that way we can hands-on learn from hands-on, do workshops. So that way, when you do the workshops, as long we got the workshops, we know that we can't do those things again because they're giving out those workshops to help us out. And there's a lot of different types of harassment. There's not only one. There must be 100 different types. So I just wanted to bring that to your attention because it offends me when the modern world tries to tell me how to go about it after residential school and the people coming back from the army treated us.
You know, I don't know. I guess just a response to that is it doesn't always need to be either or two. And I think just what you had pointed out there is providing kind of access to like to your community members, so they have resources available to them. What you want to do is we can't ever get away from the Saskatchewan Employment Act. There's no dodging that, unfortunately. But what we can do is kind of marry the two, to reconcile the two, so that our, the cultural maybe protocols are recognized, because you do have to balance competing interests and competing rights here. And that is something that, it is definitely an issue of concern for Indigenous employers, because they don't want to be operating under that total colonial regime. What you want to do is you want to reconcile, marry the two, and make it so that it's kind of part of the fabric of your workplace. At the end of the day, what is going to constitute unsafe or safe is going to depend on a whole bunch of things, including the climate of, including the workplace climate. So I appreciate those comments.
Thank you. Minister Pruden.
Thank you, Mr. Chair. Thank you, Reva, for the presentation. It's always good to be updated and reminded of all of these things. I guess my first question is, do we have a harassment policy? And if so, can it not be sent to every one of us? So, and I'm talking a policy that's not the HR staff policy stuff. I'm talking for us, a policy, because I've never seen one, and I obviously we need one. The law is mandating us to have one, so yeah, that's my question for now.
Okay, Matt, you want to speak to that?
Oh, yeah. Yeah, I'm gonna start. So, yeah, basically, we've got HR policies for the public service, which are laid out, but I think what you're saying is, are there any harassment policies at the PMC level? And I guess the answer at this time is no. There would be certain elements within the executive handbook, perhaps, but on a specific harassment policy, workplace violence policy at the PMC level, that's something that we would be happy to bring forward at the next PMC meeting for review and consideration.
Excellent.
Thank
Matt.
you very much, Matt. I know I personally have looked before for one, simply because of where I've worked in another lifetime. But thank you, and I think Riva has really made that point very clearly that it is mandated by law that we have one. And I think it would help as a PMC member, I can only speak for myself, it would help me to clarify different hats and roles that we play and kind of a process like what that looks like, or like how do I make a complaint, what happens to the complaint, like we would need something that spells it all out. So thank you for clarifying that, Matt.
Thank you, Minister. Minister Gervais.
Thank you very much, Chair. And Reba, thank you for the presentation. Yeah, there's a lot of material there to digest. It's something that you need to take a little bit of time and take a look at. And I just want to touch on a couple things. First of all, I'm going to go back to what Minister Bouvier stated from a cultural perspective. And I understand that we're living in a colonized world. We have laws, provincial and federal, that have to be followed, municipal as well. But there are pieces that are cultural practices. They may not be considered correct in today's world, but they are cultural. I was going through some of the slides, when we talk about that joking piece and stuff like that. Humor was one thing that we're known for that actually allowed us to get through, a few hundred years of trauma and colonization. So somewhere you're correct. We have to marry the two. I think there's a place for humor, but we have to also be careful that humor, and I'm coming from an educational perspective now, see it in the classrooms a lot. We have to be careful that humor isn't being used as a form of bullying, which then becomes a form of harassment, right? So I think those are some things that we need to think of as we move forward as a nation. And thank you for that, Minister Bouvier. But I also want to touch on now what Minister Pruden-Ansell stated too. We don't have anything in place as elected people. I know that we're considered employees of Métis Nation Saskatchewan, but we're also elected. And so we're kind of out there on our own little island. And all of us, every single one of us here, and every single one of us in last term has had to deal with something, either in our communities or our regions or provincially or whatever. And that is something we really need to work towards. And as we move into election time, I say that because last election, there were some real brutal exchanges on Facebook, and it impacted our community. And I don't think, we just had an excellent presentation of CFS this morning of C92, right? Talking about, our children and our families. And so this to me kind of ties it all up into a nice little package. How do we ensure that our communities remain safe? How do we ensure we remain safe? So those are some of the things that I think we need to focus on as elected. Minister Pruden asked this question in our last PMC meeting, and she commented, who protects us? And when I mean us, I mean every single one of us here as an elected official, okay, has had to deal with issues, things, whatever, comments. How do we protect us? And how do we ensure that we're not being harassed? And I'm not talking about just harassed by, by, disgruntled citizens. I'm talking about harassed by staff. I'm talking about, the slash and hack comments coming out by staff to elected officials. And I'm not saying it's any staff here, but it does happen. And so we need to ensure that those pieces are put into place. And then my next comment is I want to ask this question in a very sensitive, productive way. In the piece about harassment, it talks about ethnicity, right? And origin. So in today's day and age, and I want to be clear about this, in today's day and age, and I just referenced the discourse that's going on across Canada regarding some of the other governing nations, right? So in this day and age, how do we address those issues of pretend, I don't even want to use the word Indian, pretend nations, right? Pretend individuals, pretend First Nations, pretend Métis. We know the discourse that's going on across Canada. So how do we engage in educational, but yet respectful and mindful discussions around issues like that? If I'm going to be accused of harassing somebody because I'm asking them about their origin or their identity. And that does speak to what Minister Bouvier has spoken to. That speaks to our cultural ways of knowing and doing. Every one of us on this call that are Indigenous, whether we're First Nations or Métis, every one of us knows that within 5 minutes that we're in a room with each other or other Indigenous peoples, the first thing we talk about is who's your kin, who's your family. And if I have to be worried as an elected leader that me engaging in a discussion with a citizen or a potential citizen or another member from a governing body, if I have to be worried that asking that question, which is a cultural question, because it speaks to our identity. If I have to be worried about that I'm going to be, there's going to be a harassment complaint put in, then then I'm concerned as a nation how we move forward with things like this. So some questions to you, Reva, how we handle some of those situations.
I can't unmute her. There you go, Reva, you're unmuted now.
You got me unmuted?
Yeah.
Okay, yeah, those are some big questions. I mean, again, like as far as, if you're going to be on the receiving end of harassment complaint, and here I go, like I'm speaking to the law here, it's going to have to be brought within a certain forum, right? And so if you're receiving a Human Rights Commission complaint brought by a Human Rights Commission on the basis of something that you said as far as just in the interest of protecting the sanctity of your membership, or like the validity of your citizenship, yeah, I'm not it would depend if the complaint comes under the jurisdiction, it's going to depend on the circumstances. If it's a member of another government, I honestly don't know what recourse they would have other than just kind of generally complaining about it. If it's an employee, they would have recourse under employment related legislation. So, but I do understand kind of the concerns there. Sorry, I don't have much of an answer for you. It's a complicated issue, and I could tell you it's a shared one, that's for sure.
Thank you, Reva. And that, so here's a throw out to you to maybe bring back ultimately, because that complicates, that ties our hands, right? And the reason I say that is, like you said, if it's an employee and you're engaged in a discussion and that's seen like that's taken as harassment, right? Then how do we do our due diligence to ensure, and I'll use this as an example. If Jane Smith, comes to me and we're engaged in a discussion and Jane Smith is looking at being employed at the regional level, and we have a policy that we hire Métis people, and Jane Smith claims she's Métis but hasn't got a citizenship card yet, how do we engage in that discussion? Because we all know this. We know we usually step back and say, who's your family, right?
Mhm.
So is there some way of marrying those processes with today's law? I don't know if I'm coming off the way I want to, but we've got to find some ways to do that. Otherwise we're mired in this whole convoluted question of identity.
Yeah, I think, I mean,
Yeah, Riva, I think Hillary's going to speak to this, and then we have to move on to the next question, please.
So I'm building off of what Riva had said with reference to the Canadian Human Rights Act, the Saskatchewan Human Rights Code. Is as an Indigenous government, it would be my position that we would fit as a program. What that means is that because of our distinctness and our need to maintain our distinct government, that in theory we can ask questions about people's background. Now, to be clear, I'm not certain the example that's being brought forward, but our registry is able to, that's where the questions about citizenship, who someone is or who their family is. Now, a question about, where are you from or who your family is, I don't believe that there would be a suggestion that that's discriminatory. So I'll leave it at that.
Thank you, Hillary. Minister McLennan, and then it's going to be time to move into in camera, and I believe Richard after Minister McLennan.
What about you? Are you on the speakers list?
Thank you for the presentation, Riva. I have a few things to say. Right now, I don't know how to feel. I've been a professional. I've been working since I was 12 years old, so which is 50 years. I have never gotten in trouble in any job that I had. But I feel since I came into this position, I don't even know if I even want to speak anymore. That's how I feel. I'm scared to speak. I'm scared to say anything. I'm actually at the point where I want to give my portfolio back, because right now I feel like I'm being colonized again. I understand we have to have a policy and all that. I'm good with that. I just feel like the election's coming up, and this is being thrown at us now, like months before the election. What if somebody doesn't like me and they put in a complaint, and then I can't run in the election? That's my concern. So that's number one. Number two is I agree with what Wendy and Minister Bouvier said about culture, because I like to joke around. That's how I am. I don't want to fight with people. I throw a joke out there. So I'm going to get in trouble because I joke with somebody. I'm going to get a harassment charge because I'm joking with somebody. As Métis people, we like to joke around. And maybe that's our way of, getting out of that difficult situation. So right now, I don't know how to feel. I don't even know if I'm going to speak again for the next 4 months, because I know how I felt when I got thrown into that truck incident. my heart still hurts because of how my colleagues treated me and what I was put through. Yeah, I don't know. I just feel like we're being colonized again, and this is being thrown at us right now. This should have been, maybe we should have did this a long time ago. I don't know. That's just how I feel. I'm just saying how I feel. Thank you.
Thank you, Mr. Quintel, and then we'll move into camera.
So thank you very much for the presentation. And just, you know, I did ask for this to be done out of camera because every time something's complicated, everybody always acts like they've never heard about this before. They've never seen it before. Never, you know what I mean? This is the 5th presentation you've had on this. 5 times. You have 1 employee, and that's me. I've been working for you as your CEO, and may I remind you, you came to me and asked me to be your CEO 8 years ago. For 8 years, I know some of you are not as far along on the healing path as maybe you want to be, and I've understood that, the whole cultural part. But I'll tell you one thing, what happened at the MNLA is completely unacceptable. Humiliating me, attacking me, ensuing bullying from online bullies and trolls that nonstop coming after me. I had to take time off work because my family was hurt. I have amazing leaders around the table, and there's 4 of you that are not right. You're the ones who stand up and speak right now about all of this. I'm telling you right now, you are the ones who are doing the bullying. You harass me. You try to intimidate me. A lot of citizens and elders and local presidents reach out to me. I know what's going on. I know you're continuously out there talking and defaming me. I'm telling you right now, I had enough. I am your employee. I do have rights. I am a citizen and I am human. There's 350 staff behind me and I will not stand quietly. You cannot treat people this way. We serve the citizens of this province. 8 years ago, when you asked me to start this job, you had nothing. I brought in, and I never say I. That is not something we do within this government. We don't allow it. We talk about we because it takes everyone. But I did bring the right people, amazing people into this government that built this government so strong. I had enough. Sherry McLennan, Wendy Gervais, Lisa McCallum, and Kathy Pruden. I'm putting you on notice. I have had enough of what you do to me, what you do to my family, and what you do to me as an employee. I have had enough. And this is the 5th time you've had this presentation, so I hope you were listening. Eco say.
Thank you, Richard. Can I get a motion from someone to move in camera, please?
Can I respond, please?
Nope.
I'll make a motion.
Thank you,
Okay.
President McCallum. Can I get a second?
I'll second Laura Burnoff.
Thank you, Laura. All in favor? Can we get the poll up, please? All in favor of going in camera? Plus President McCallum here. And that's enough. All right, we're going to go in camera. Thank you very much. Stop the broadcast. Thank you.